Good morning, distinguished guests, and participants of the International Investor-State Mediation Competition, IIMC Colombo 2022. I, Ranadi Premasinghe, will be your host today, and it's a great privilege to welcome you all to IIMC Colombo's first event, UNCITRAL and the Path to Investor-State Dispute Settlement, organized by the Moot Court Bench under Asia Pacific Day 2021 in collaboration with the UNCITRAL Regional Center for Asia and the Pacific and Sri Lanka Law College. To begin today's event, I warmly welcome Sadia Rial, Head of Mediation at the Moot Court Bench, to deliver the welcome remarks.
Thank you, Ranadi. I also extend Ranadi's warm welcome to all of you, and thank you for your participation in today's AP Day event, IIMC Colombo 2022. Now, to start off with who we are and what we do, the Moot Court Bench is Sri Lanka's first fully integrated legal advocacy training platform, which aims to enhance the standards of the legal profession by delivering education of global standards for the law students of Sri Lanka. We have a focus on arbitration, international trade law, negotiation, and what has brought us together today, mediation. Now, the mediation MCB wing, I am proud to say, has made waves in Sri Lanka with our appraised mediation initiatives, such as our International Mediation Training Program and the inaugural National Mediation Competition. At the core of our work is the belief that education is the immortal soul of our society, and an investment in knowledge pays the best interest. Which brings me to IIMC, the world's first investor-state mediation competition. Now, I must take a moment and thank Professor Rajesh Sharma, a crucial member of our panel of advisors and longtime mentor for many of my colleagues, for helping us give life to this project. The heart of this event is powered by our purpose of developing and revolutionizing the local as well as the global ADR landscape. And one of the many avenues through which we achieve this is by creating the next generation of skilled mediators as well as advocates, equipping them with the skills that they need so that they can use strong foundations that are laid by institutions like UNCITRAL as stepping stones to become regional and international leaders in mediation and dispute resolution as a whole. Which is why I'm honored that the MCB is taking Sri Lanka's very first step towards establishing investor-state mediation in collaboration with UNCITRAL's Regional Center for Asia and the Pacific and Sri Lanka Law College. Headed by Atita Kominder and her impressive team, UNCITRAL RCAP hosts AP Day as one of the center's flagship events. And the event's aim is to raise awareness of UNCITRAL's texts and the importance of legal harmonization amongst law students. And this perfectly aligns with the aims of IIMC Colombo, which is why we deeply appreciate our keynote speaker, Judith Naiper, for being the voice that represents our collective efforts. Now, the pillar that connects IIMC and UNCITRAL RCAP with our intended audience of this academic event is Sri Lanka Law College, our island's foremost legal education institute, which nurtures the minds of our future generation of legal professionals. And I must thank the principal, Mr. Abdullah Batinayaka, and the deputy principal, Mr. Shehan Pereira, for co-hosting Sri Lanka's first AP Day event with us. With that, I extend my gratitude to all of you once again for joining us as we take this united first step, and pass the floor back to Ranadi.
Thank you, Sadia. Mr. Shehan Pereira is Deputy Principal, Lecturer and member of the Board of Examiners, and a faculty member in charge of student organizations and co-curricular activities at Sri Lanka Law College. I invite Mr. Shehan Pereira to address the gathering.
I feel honored to speak at the inauguration of this pioneering project. The International Investor-State Mediation Competition, organized by the Moot Court Bench, will offer students an unprecedented learning opportunity. I know that this competition will help to create a generation of young professionals with the skills to become leaders in the field. It will also offer many an attractive career prospect. Sri Lanka Law College is the only gateway to the legal profession in Sri Lanka. So molding the legal profession must begin here. And I'm very happy that we have always been able to collaborate with the moot court bench. Having dependable yet hassle-free dispute resolution mechanisms in place is a must for a country like Sri Lanka. We must build confidence in investors to draw in new investments. This is a dire need of the hour. I feel mediation will have a significant role to play here. I have had the privilege of being associated with the moot court bench and have come to appreciate their professionalism in all their projects. From their communication to implementation and follow-up, their modus operandi has been exemplary. I wish you the very best for a productive and enjoyable program. Thank you.
Thank you for your words, sir. Athita Kuminder is head of UNCITRAL Regional Center for Asia and the Pacific, managing technical assistance and capacity building programming available to over 50 states in Asia and the Pacific in key areas of commercial law, including dispute resolution, MSMEs, international contract practices, sale of goods, electronic commerce, transport, insolvency, international payments, secure transactions, and procurement. In that capacity, she coordinates with governments and international and regional organizations with respect to trade law reform activities to achieve sustainable development goals. She has 20 years of experience in the fields of international trade and economic law, arbitration, multilateral dispute resolution, and the rule of law and development. Prior to joining the United Nations, Athita mainly advised and worked with numerous Thai agencies, including the Thailand Institute of Justice, the Thai Ministry of Science and Technology, and the Thailand Arbitration Center, where she managed the Arbitration and Legal Affairs divisions. She also worked for the Thai Ministry of Commerce in Bangkok and Geneva, representing Thailand in bilateral, regional, and multilateral trade negotiations, World Trade Organization dispute settlement, and treaty drafting. Athita, the floor is yours.
Principal of Sri Lanka Law College, Atula Patinayake. Deputy Principal of Sri Lanka Law College, Shihan Pereira. Professor Rajesh Sharma. Head of Mediation at the Moot Court Bench, Sadia Rayal, and the mediation team under her leadership. Students, participants, and staff of the IIMC Investor State Mediation Competition, Colombo, 2022. Greetings from the United Nations Commission on International Trade Law, Regional Center for Asia and the Pacific, or UNCITRAL RCAP, in Incheon, Republic of Korea. I'm Athita Kuminder, head of RCAP, which is UNCITRAL's only regional center. The RCAP doors opened in 2012 with support from the Korean government and in-kind contributions from the Korean Ministry of Justice and Hong Kong SAR Department of Justice, enabling UNCITRAL RCAP to carry out UNCITRAL's mandate of promoting the progressive harmonization and modernization of international trade law in approximately 60 jurisdictions across the Asia-Pacific region. Today's event, in addition to launching the IIMC Colombo 2022, is also part of the UNCITRAL Asia-Pacific Day, an annual flagship academic series launched in 2014 by UNCITRAL RCAP to celebrate the establishment and work of UNCITRAL in the region. This year, an initial 34 universities and institutions in 13 jurisdictions across the Asia Pacific are joining the celebration by co-hosting a series of 20+ academic events with UNCITRAL RCAP. In so doing, we have collectively raised awareness of the role of UNCITRAL in the international trade law landscape to thousands of law students and other stakeholders. It is therefore particularly opportune that today's activity, which preludes the first ever investor-state mediation competition, thus innovatively broadening and deepening students' understanding of the UNCITRAL mediation framework, is also Sri Lanka's first UNCITRAL Asia Pacific Day event. In this connection, I am delighted to deliver these opening remarks and thank the co-organizers and invaluable supporters, including Professor Sharma, for this special opportunity. Legal harmonization lies at the heart of UNCITRAL's work, and your participation in IIMC Colombo 2022, delving into complex analyses of the Singapore Convention on Mediation, investor-state mediation, and investor-state dispute settlement, illuminates how legal harmonization is the driving force of international trade, particularly in the post-COVID era. Over the last 50 years, UNCITRAL's widely accepted instruments have bridged the gap between the civil law and the common law, offering solutions appropriate to different legal traditions and to countries at different stages of economic development. We stand ready to continue to do so in all areas of international trade law, including those crucial to weathering COVID, which in addition to mediation and dispute resolution, range from sale of goods and the digital economy to insolvency and creating a streamlined and simplified legally enabling environment for micro, small, and medium-sized enterprises. I am also delighted at the high level of interest and enthusiasm garnered by the inaugural IIMC, impressively attracting 16 negotiator teams and 8 mediator teams from over 10 diverse jurisdictions, more than half of which hail from the Asia Pacific. Last but not least, I am very pleased to introduce my colleague, UNCITRAL Legal Officer Dr. Judith Naper, who is based in Vienna and services UNCITRAL Working Group 2 on dispute settlement and Working Group 3 on investor-state dispute settlement reform. Judith is responsible for mediation within the UNCITRAL Secretariat and also qualified and certified as a mediator, thus most deserving of the affectionate informal title of Madame Mediation. Judith will be delivering the keynote address on UNCITRAL and the path to ISDS, comprising a comprehensive overview of UNCITRAL's role in establishing investor-state mediation and investor-state dispute settlement, the current status of Working Group 3 discussions, and the UNCITRAL mediation framework, including the Singapore Convention on Mediation and new instruments. With that, I pass the floor to Judith, along with a final note of thanks to all our co-organizers and supporters for making this important activity and competition possible. Best of luck to all participants. Thank you very much.
Thank you, Athita. The next speaker, Dr. Judith Naper, is a legal officer at the Secretariat of UNCITRAL in Vienna. She services Working Group 2 on dispute settlement, Working Group 3 on investor-state dispute settlement reform, and is responsible for mediation. Until her appointment to the Secretariat, she had been working in Southeast Europe from 1998 to 2013 for numerous donors and organizations, like the Organization for Security and Cooperation in Europe, World Bank, and GIZ. She obtained both legal state exams in Frankfurt, Germany, as well as her PhD, and is also qualified and certified as a mediator. Ladies and gentlemen, Judith Naper.
Thank you very much. Good morning to all, or good afternoon, depending on where you are. From my perspective, it's really the morning because it's 6 o'clock in the morning. It's a great pleasure to be here, and I hope that I could share my screen with you. Could I? Do you see my screen?
It's visible, Judith.
It's visible. Okay, perfect. So we overcame the technical hurdles already, which is a good step forward. So it's a very great pleasure to kick off this several day lasting event. And I have to echo my colleague Atita in her thanks, because setting up such an event that lasts several days is really not possible without the support of many. So we owe our thanks, of course, to the Sri Lanka Law College as being our co-organizer. And especially I would like to highlight our thanks to the principal of the Sri Lanka Law College, Mr. Atuta Patinayaki, the deputy principal of Sri Lanka Law College, whom we heard also several minutes ago, Mr. Shehan Pereira, Professor Rajesh Sharma, for having had the idea, as I learned today, and for facilitating the partnership and for mentoring also the teams. Of course, our thanks, and we also heard her also, to Ms. Radia Rehal and her mediation team, as well as to Suleiman Rames, who is the presiding partner of the Mood Court Bench. I also have, of course, I'm in Vienna, as you heard already. I have to thank my colleagues from UNCITRAL ERCAP, who did all the work, the preparatory work, which is very much appreciated. And I would also like to thank our speakers and panelists of the events to come. So I would urge you to really take advantage of these days and to join what they have to say. From the Secretariat perspective in Vienna, we are happy and relieved for several reasons. And this is first that we overcome all the restrictions that are linked to COVID-19. It would, of course, be nicer to join you in person, but this is not possible for obvious reasons. So I'm very happy that we at least have the chance to meet. And I would like to take that opportunity to ask you to really jump in so that we are really e-meeting. The idea is not to deliver a keynote speech and you are just listening in, but the idea is to allow you to really ask questions and to maybe that we can engage in kind of discussion. So you have several ways of asking these questions, either directly personally by just switching on your mic after having raised your hand, or by putting your question in the chat. We are also very happy that we are able to support the Mood, which is a very good way to promote the development, the understanding, the use of international dispute resolution instruments globally. And I'm very happy that we have such a diverse group of listeners who are coming from Australia, Brazil, Czech Republic, France, Hong Kong, India, Kenya, Nigeria, Singapore, Sri Lanka, of course. So this is really promising to have such a geographical diverse group. This is really what is the essence of UNCITRAL. And thirdly, this event is very much welcomed for us because we are currently discussing mediation in the context of Working Group 3, which is the working group that works on the possible reform of investor-state dispute settlement. And in that context, mediation has a big role to play. What I wanted to do today is have 3 parts. First, kind of introduction and to let you know what UNCITRAL is and how we do work. Second, discuss with you the UNCITRAL mediation framework, and it was already mentioned by several of the speakers. And finally, shortly discuss where we stand regarding Working Group 3, which is on investment mediation, so probably of particular interest of you. And really, once again, just interrupt me if something is unclear, or if you would like to discuss, or if you want to chime in. Please don't be shy. So UNCITRAL has been created 50 years ago. We had our 50th anniversary, depending how you see it, in 2016 or 2017. If you take the General Assembly resolution establishing UNCITRAL, 50th anniversary was in 2016. If you take the 50th session, then it would be 2017. UNCITRAL would not have created without the New York Convention. The New York Convention that predates the establishment of UNCITRAL showed that states could work together, that they could agree on a very technical text, and despite all these very large differences, geographical differences, ideological differences, they could agree on a technical legal text. And here you see some photos of the signing ceremony. Another crucial aspect in this setting up UNCITRAL was the political situation the world was in. There was a division between the powers, US on the one side, Soviet Union on the other side. It was the time of Cold War. It was this speech, 1963, where you see Kennedy in the General Assembly, was shortly after the Cuba missile crisis. And the Cuba Missile Crisis was the moment when the US and the Soviet Union agreed that they need to agree to disagree and work together on a technical level. So that was one crucial moment for the creation of UNCITRAL, that you really should always try to come together, even if you are coming from very different point of views, political point of views. So what is UNCITRAL? UNCITRAL is an intergovernmental body with a limited membership and is mandated to modernize and to harmonize international trade law. Limited membership, you might say, how does that get together with universal standard setting? This is because at the beginning, when we discussed setting up, when the establishment was discussed, it was discussed whether everyone should be involved in these technical discussions, or whether it would be better to have the discussion led by experts, a smaller group, and then have the text adopted in the General Assembly. So the outcome was a compromise to say it's better to have a smaller group, to not lose yourself in political discussions, but really try to find a way to solve these technical questions, and then have the text advertised to everyone. The way we are working today, we still have limited membership, 60, but we do invite all states. So if we have a working group session, if we do have a commission session, we do send out 193 invitations to all United Nations member states. So although we still have this distinction between member states and observer states, de facto everyone is able to participate. Here you have some of the, on this slide, you have some of the political reasons why UNCITRAL was created. So you could, and if you see the slide of today, these are quotes from the times when UNCITRAL was created. So here you could see that somehow it's still very modern. The need for uniform rules for international trade, that differences in national law are an obstacle to develop world trade, create uncertainty, dispute, add to transaction costs, and all of that. So these were these quotes show that we are still facing the very same problems somehow today. Membership, already touched upon it quickly. So we have 60 member states. They are elected always for 6 years in their respective regional groups. The member states are elected every 3 years, so that half of the commission get exchanged every 3 years to ensure continuity on the one hand, and on the other hand, make sure that we always have newcomers. In order to make sure that the world is properly represented, that you have the various geographical regions, that you have the principal economic and legal systems, we have a reserved number of seats according to the distribution you see on the slide. So we always do have 14 states from Africa, 14 from the Asia Pacific region, 10 from Latin America, 8 from Eastern Europe, and 14 from Western Europe and others. Here you could see that UNCITRAL is a child of Cold War, because you do have European Union member states that are still in 2 regional groups, Eastern Europe and Western European group. And then, as already said, we do invite all other states as observers, and we do invite a number of organizations to make sure that when we discuss a text, that the whole knowledge is in the room, and that we could really produce the best possible text, taking into account all issues that might arise. And the way we are organized, we have the commission, which is the main, this is UNCITRAL, so to say. So here on the level of the commission, you do take the political questions, what are the areas we are working on. The commission is evaluating the progress by the working groups, and so on and so forth. The working groups are the groups where you have the technical work that is done. We have 6 working groups currently going on. And the secretariat is where I'm working, and the secretariat are servicing the working groups, are servicing the commission, and are also involved, and this is what I'm doing this morning, in promoting the work we are doing. So the commission is having the meeting once in New York, 1 year in New York, 1 year in Vienna. Obviously, with COVID, everything is a little bit different. So we had it in a hybrid way. And here you have, again, the work we do at the commission. By the way, you can have the slides, so there's no need to take notes. The slides will be sent to the organizers, and they could forward them to you if you do want. This is a slide to give you an impression that I took of one working group in the coffee break. That's why there's not so many people in the room. You see the podium where you see people from the secretariat. We are taking minutes of the discussions, and you see the chair who is elected among the member states and who is moderating the discussion. Both the commission and the working groups are working in 6 languages, in the UN languages. We usually take discussions on a consensual basis. There have been, in the history of UNCITRAL, we could vote, but so far there have been only 2 votes. So one vote related to the question whether the secretariat should move from New York to Vienna, where we are currently located. And the second vote concerned the question who would become the chair of working group 3. So these were the 2 only votes we witnessed so far, which shows that in more than 50 years of existence, that consensus is really for us the way the way to go. And here you do see the working groups we are currently having. If you want more information on whatever working group, please let me know. Or if you want more information on UNCITRAL January, also please let me know. By the way, as many of you are studying maybe an interesting information, we do have an internship program, so you can come both to ERCAP and to, as well as to Vienna, for 2 to 3 months to get acquainted with the work we are doing. The job openings are posted twice a year, usually in December and in June, which would be the next opening. Now I'm coming to the mediation framework. So the most the text that triggered most attention in recent time is, of course, the Singapore Convention, which has been open for signature in 2019, entered into force in 2020, and has already today 9 parties, which is very quick for a convention that you have in that a text enters into force after 1 year only, because you need a certain number of states, and these processes that allows you to join an international convention are usually quite long. So 9 state members after only 2 years is really very quick. We have model laws. We have the model law on 2002 on commercial conciliation, and here maybe with respect to our terminology, from our perspective, conciliation and mediation are 2 terms that are used interchangeably from the UNCITRAL context. This is different in other situations. For instance, ICSID has mediation rules and conciliation rules. So there is a difference in terminology. From our perspective, we are now switched to with the finalization of the Singapore Convention. We decided to have as a lead term the term mediation, because this is the term that is much more used and is much easier to promote than the term conciliation, which is the reason why our lead term is now mediation, but we never changed the definition. So it's still the same approach we had when we started in the working in the area of conciliation mediation, which was already in 1980 with the UNCITRAL conciliation rules. So as said, we have the UNCITRAL model law on commercial conciliation. This model law has been updated when we negotiated the Singapore Convention, and the 2018 model law now consists of the 2002 model law, plus an additional section has been added, which concerns the issue of enforcement. Then we have contractual texts, and as already said, the first contractual text dates back to 1980. These are rules parties can choose if they agree to settle their dispute in via mediation. They can then opt into our rules. By the way, all of these texts are of a generic nature, so they could be applied in both ISDS investment, or they could be applied in other type of disputes. And then we also have some explanatory texts. They are both very recent. One are the notes on mediation, which do explain generally what mediation is all about. And we have a guide to enactment and use of the UNCITRAL model law, which explains article by article what the working group discussed. So it's based on the travaux préparatoires, but gives you kind of explanatory background. So maybe with a little bit more detail, Singapore Convention, which triggered a lot of attention, and you see here two of the quotes which were very typical, one could say, when the Singapore Convention was signed. And you see here the reference to the New York Convention. This reference was done throughout the negotiations. So the New York Convention was somehow considered as an important template, but of course with many differences, because the arbitration procedure and the mediation procedure are really quite different. But the structure and the approach in the Singapore Convention and the Mediation Convention is quite similar. So here you have the status of the text. We have 55 signatories as of today, and in that respect, it's really important to consult our website on a regular basis. Georgia, for instance, deposited its instrument of ratification only 2 weeks ago on the 29th of December. So we have a lot of changes in that regard. Today, we have 9 countries that had ratified the convention. So 55 signatories and 9 ratifications already. Here you see the map, and you do, and this was done by Ilda Casa, who is an intern at UNCITRAL and who is currently listening. And she also highlighted the states that are signatories to the UNCITRAL, to the UN Convention on Mediation, the Singapore Convention. So you have Australia, Brazil, India, Nigeria, and Sri Lanka who signed, and Singapore, of course, already did ratify. And if someone in the room knows where Sri Lanka or any of the other states stand regarding their ratification process, that would, of course, be interesting for us to know. The Singapore Convention, here you have a quick overview of the different articles. Maybe to have, I think we have time, a little bit of background. The scope of application has been subject to many discussions, and here you see the result. Certain disputes are taken out of the scope of application, for instance, personal family inheritance and employment matters, because there you have a number of national regulations that are not so suitable for harmonization, and these topics generally do not fit into our mandate, because we have as a mandate harmonization of and modernization of international trade law. And then we also took out the settlement agreements that are enforceable as a judgment or as an arbitral award, and this is because we do have other conventions that are fit for purpose in that respect. Of course, very important for all UNCITRAL texts is always the part on definitions. If you try to find a common agreement on international text, you need to spend some time on definitions, because as you know, in the national context, terminology might change considerably. So definitions are always crucial from our perspective. Article 3 is the heart of the Singapore Convention, because it contains the obligations of the state parties who are joining the Singapore Convention. So if you are a signatory, if you ratified the Singapore Convention, you need to enforce settlement agreements, and you need to let disputing parties invoke such settlements in a dispute. Article 4, you have all the requirements for reliance on settlement agreements. 5 is very important, of course, and again modeled according to the respective article in the New York Convention, because this is the article that lays out which are the grounds for refusing to grant relief. And these are so you have some reasons that relate to the parties themselves, incapacity. You have reasons that relate to the settlement agreement, and you have reasons that relate to the behavior of the mediator. The slide was, because there was already so much on the slide, the serious breach of mediation standards and is not sufficient. So it needs to be linked with, and this is what the text says, you need to have the serious breach, and because of that breach, parties agreed to have the settlement agreement. So this is important, that without the breach, you would not have a settlement agreement, which is a much higher standard than just have a serious breach of standards. Then you have some rules on the parallel application of claims. Article 7 that you would also find in the New York Convention. And then you have some reservations, only 2 reservations that are permitted, and this is explicitly spelled out in the Singapore Convention, that only these 2 reservations are permitted. The first one is probably of higher interest to you, because this allows states to not really use the Singapore Convention in the context of investment mediation. And then you have, of course, the important question that the settlement agreement need to be concluded after the convention entered into force, so that parties to disputes are not surprised by the application of the Singapore Convention. The model law, as already said, we took the model law from 2002 and drafted the 3rd section in parallel to the Singapore Convention. So you will see, if you compare the 3rd section and the Singapore Convention, that much of the text is identical. If there are differences, these relate to the fact that they are different texts. So a convention, of course, has a number of very specific articles, for instance, relating to the depository or to the entry into force. These are issues that you do not need in the model law. So there are differences, but the idea is really to have the same text as far as possible. And you have, as I already mentioned, you have this guide to enactment, which explains article by article the model law. The model law is much broader than the Singapore Convention, because the first section, the second section especially, do contain a number of rules for the whole mediation procedure. So this is really from the start of the mediation till the enforcement, you would find regulations for everything. Whereas the Singapore Convention is only focusing on this question of enforcement. The mediation rules were adopted this year in 2021 at the Commission session, and this was done because we were giving the mandate to update the UNCITRAL conciliation rules to first reflect changes that became necessary because we have two new texts, the Singapore Convention, the model law, and then to reflect all the other changes that occurred during the last 40 years. So this is the mediation rules entered into force in July 2021, not this year, sorry, last year. I'm still not acquainted to that we are already in 2022. So it was adopted at the last year Commission session. And here you see a screen how the mediation rules do function. I leave that to you to consider carefully, but again, the mediation rules do contain an overview of the whole mediation procedure, and parties could, of course, vary any of these rules and use the rules as default rules in case they have no agreement. Then you do have the mediation notes, and the mediation notes are only an explanation of mediation. They do not try to promote any kind of best practice, but really try to give a general overview that fits for all the different type of approaches you might find. And this is, of course, a text, an explanatory text, so of course it's not binding. And here you see the overview of the different notes. So if you are in a mediation, you can consult the notes according to the stage you are in. I'm coming to the last bit, which is the bit mediation in the ISDS context. So this is, we are now switching from our framework we developed, and that is should be fit for purpose for all kind of different disputes, including investment mediation, to now the question mediation in the ISDS context. This is here I cannot really present any text to you yet because we are in the middle of the discussion. So there's no result so far. There are two notes by the Secretariat. You find them on our website, where we tried to outline the several model clauses and draft guidelines. And we received comments by states, but it has not been discussed specifically in the working group session. So this is what we still need to do. And you can, if you want, on our website, closely follow what is going on in that regard. And by the way, all of our sessions are audio recorded. So if you have a lot of time, you can listen to the whole discussion. If you have less time, you can go to our reports where you have the summary of what happened in the meetings. And the reports are also adopted by states, so you can rely on the report as being really a source of information. It's not something that the Secretariat did, but it's something that the Secretariat drafted and that has then been adopted paragraph by paragraph by the states that were there. So it's quite a reliable document. The three questions we were given by the working group, we were asked to develop is draft model clauses, draft guidelines, and draft rules. For the rules, we were in the Secretariat not so convinced if this is really necessary, because you have some specific rules for investor-state mediation, the IBA rules, you have the ICSID rules, and you have the generic UNCITRAL mediation rules. So we put in front of the working group the question whether the rules are really necessary or whether it would be sufficient to work with what is already there. The question model clauses is, of course, a question that needs to be looked at. Now, if you have a look at treaties, you will see that some of them do mention mediation, and generally as a possibility in the cooling off period, which is a period before you could start mediation. But generally, these clauses do provide no guideline to neither to states nor to the investor how to start the mediation procedure, and which results in this cooling off period not really being utilized properly. Usually, all the parties wait that this period of time elapses and do not really try to go for mediation. And this is something that states want desperately to change. So they look for methods how mediation could be increased, how the hurdles that government officials face in a mediation, how these hurdles could be overcome. And the questions we still have to consider is how should maybe mediation become a method that would be available to parties throughout their time of contact. So not only as a pre-dispute settlement or pre-arbitration, to say it more correctly, pre-arbitration method, but also to have it as a method during the arbitration and after the arbitration. So to allow states to be more flexible, they could maybe split a certain part of the dispute, have that part resolved by arbitration, have the rest resolved by mediation. All of that still needs to be discussed. So what we did in our text was to try to have to develop some model clauses to have a higher level of conduciveness towards mediation. So what is clear? So no arbitration is. I have a red thing on the screen, which I don't know what that is. Do you see that? Or interesting. I hope you don't see it. There's a red line, which I don't know where it comes from. So no clause of mediation is if this would not help you in having a more conducive level. The most conducive way would, of course, to have mandatory mediation, or at least to undertake the starting of mediation. This is what the working group will have to discuss, which way they do want to go. This red line disappeared, so maybe I did something or maybe not, I don't know. Here you see the time frame that is important. So do you want to have mediation as something that takes place before arbitration, or do you want to have it throughout the time? Then you have, of course, certain procedural matters you would have to take care of. So which rules should be applied? How should the mediation start? So what are the requirements for the written notice on mediation? How could the without prejudice provision look like? How would you have to deal with confidentiality? So all of these issues are on the table of the working group. And of course, the settlement, how could the settlement agreement look like to also make it enforceable under the Singapore Convention? If we look at mediation in the context of investment mediation, we always need to take care of all the other reform options that are on the table, because we are not looking at investment mediation, we are looking at ISDS reform generally. So we do have to take into consideration the other reform options that are discussed, for instance, third-party funding, dispute prevention measures, impact of the advisory center that is also on the table to be established. The draft guidelines on mediations, again, would be a text that is not binding, but would provide background information to all the possible stakeholders to enable states to think of what might be the possibilities to enhance the use of mediation, and also inform potentially the investors what are the issues to take care of. So that would, like the mediation notes we do have already for mediation generally, that would be one text along the very same lines for investment mediation only, so a more specialized text, so to say. And here you see the content of the guidelines that are currently foreseen. So the questions, to sum up, the questions that are in front of the working group: do we need additional rules focusing on investment mediation, given that there are already other rules available? What should be included in the UNCITRAL guidelines, and always taking into consideration the other reform options, so that in the end we have a reform option that fits well into the overall reform solutions. So thank you very much for your attentions, and I do hope that we get now many questions. For the time being, I'm only seeing some. Let's see. What sort of contracts are subject to UNCITRAL mediation? Everything. I mean, the mediation rules are broad enough, and the mediation model law as well. The idea is really to have a broad approach. You have the limitation to commercial mediation, but our use of the term commercial is also very broad. So we do include investment, for instance, is included in our definition of commercial. You do find the definition, you do find it in our model law on commercial arbitration, where you have a footnote where states agreed on this very broad definition. Any other question?
The floor is open for questions. Please raise your hand or add it to the chat. Also, we've received a question in the private chat. I would like to read it out for you, Judith.
Okay.
How has the 2021 mediation rules evolved from the 1980 conciliation rules?
So what we did is what we had to take into account are the development to align them with the Singapore Convention text, and to align them with the new parts of the model law. Then we have modernized the text we have reordered certain provisions so to make the text more accessible and to also better reflect what happened in the last 40 years. If you go on our website and you go not on the mediation rules, but if you go on the document that has been before the Commission 2021, you have some explanations of all the changes that have occurred. So there you can really see what are the differences and what has been done.
Thank you, Judith. If there are any more questions, you may ask them now.
I think I see the hand of Professor Sharma.
Yes. Thank you. Judith, I just wanted to take this opportunity to ask two questions from you. One for students to know about it. Could you explain that why in Singapore Convention, the reciprocity reservations were not included, and why the seat is not included in that one? Because the students and arbitrators tend to compare this one with New York Convention. So this distinction is supposed to, like, it's good for them to know about it, and perhaps you are the right person to explain it to them. And the second, for the ISDS mediation, in that context, what is the view, or what is the general, view coming up? Do we need a special training or a special skills for the mediators who are dealing with the investor dispute, or a generic, specific, or generic, like a training and a skills would be necessary for people to act as a mediator in ISDS dispute or mediation? These two things, if you can.
Okay, thank you very much. Very good questions indeed. So regarding the first question, the issue of reciprocity, this is indeed a question that has been discussed in very lengthy in the working group, and the idea is that mediation is much more flexible. So you don't really need a seat. You could have the mediation, you could have it entirely virtually. And if you have no seat, then this idea of reciprocity doesn't really make any sense. So it's related. You have the difference is related to the differences in the procedure. So arbitration is much more formal, requires a seat, requires to know exactly what is applicable, and to take account of the flexibility in mediation. The working group decided not to have this formal approach. So this really relates very much to the differences in the procedure. It's a very good question indeed, because a lot of states have issues with this missing reciprocity, so to say, because they are used to have it in the context of the New York Convention, where, from my perspective now, with 169 parties, you don't really need reciprocity anymore, because nearly everyone is already party to the New York Convention. But it's an issue for a number of states. So the answer is because the procedures are different, because you do not need a seat, and we wanted to account for this flexibility that is inherent for the mediation procedure. Regarding the second question, which is also a very good question, I'm not sure that I'm the right person to answer that, because we decided not to get into this issue of standards. Again, the approaches on a worldwide scale are very different. So it was raised, and it was said that probably we would not be able to agree on any kind of standards of mediators or what kind of education should be necessary. And for that reason, I'm not really the person to answer that question, because there is no, from the UNCITRAL perspective, there have not been standards that have been set, because the approaches are too different. Maybe in certain period of time, like for enforcement, when we discussed the model law in 2002, the UNCITRAL could not agree on the method of enforcement. They could just agree that the settlement agreement are enforceable, and then this Article 14 at the time in the model law says, and each state has to find its own way. So maybe a certain point in time we would be able to, 20 years, we would be able to agree on a harmonized approach on mediators education. For the time being, we have no such common approach.
Judith, I'm also going to jump in and ask another question. So sorry, Ranati, just give me a quick one. So we're in the process of drafting an arbitration act for Sri Lanka, and there have been several drafts that have been submitted, and there have been stakeholder consultations. The challenge here seems to be that our courts take a really long time to enforce a contract, and because a mediation settlement agreement would be viewed as a contract, we're wondering whether it would make sense to create a special procedure for courts to recognize a mediation settlement agreement in an expedited manner. Has that been done anywhere else in the world? Is that something you would recommend?
I mean, what the Singapore Convention does is giving a special status to the settlement agreement. So to say it's not a contract in the traditional sense, but it's a contract that ends a dispute and thereby is enforceable under the Singapore Convention. Sri Lanka is a signatory to the Singapore Convention. So when in this ratification process, they would need to see how to be able to cope with the Singapore Convention, how to take over the duties. It would, if you say it's a normal contract and you have to follow the normal contract procedure, Sri Lanka would probably not be in compliance with the Singapore Convention. The duty of the state is in Article 3 is very clearly spelled out to say you accept settlement agreements and they should be directly enforceable, so as not to have the state rechecking the whole contract. You would just check these grounds in Article 5. But we would be very happy to get involved into that discussion if Sri Lanka is currently discussing that issue. So we do provide advice for the implementation of all of our texts. So if you are currently discussing the way forward, we would be very happy to get in touch with the responsible people to have this discussion in detail.
Certainly, I'll make sure there is a follow-up on it and put the people in touch.
Thank you. We have received another question in the chat, which I will read out. Could you please elaborate on reciprocity in mediation?
I think that was the question that Professor Sharma already had. So that is linked to the different procedures. If that person wants to have more specific information, I'm happy to provide some by email with links where it has been discussed during the working group.
Yes, thank you. Are there any more questions? You may raise your hand or put them in the chat.
if you have no question now, I'm always available for any questions that comes to your mind later. So the organizers have, of course, my email. You feel free to give it to everyone. So we can be in touch after that event as well.
On that note, I think we can proceed. Thank you for sharing your insightful words with us, Judith. I am confident that our audience has had significant takeaways from your speech, while the competition participants will find what they learned today valuable in their preparation for the rounds. The students and professionals joining us have gained deeper insight to UNCITRAL's significance and the future of the mediation sphere. With that, we have come to the end of IIMC Colombo's APD event. I would like to take this time and thank our speakers, hosts, and distinguished guests for your contribution and participation. For our competition participants, this is the start of an exciting adventure, and I wish you all the best in your endeavors. Thank you, and have a lovely day.
Thank you, everyone. I will move our professionals back into the breakout room. And like Judith said, we will share the presentation materials with you because I believe they are of great value, and we will give your email address once again, though I see Judith has also added it in the chat. Feel free to stay back and chat with us if you would like to, but we hope to see you in our second event tonight at 7 p.m. IST with an equally exciting panel. Thank you, everyone. Have a great day.